So we're continuing to look at Rule 410. And in the Mezzananto case, we're looking really at the opposite of Rule 410, or rather whether the parties can agree that Rule 410 will not apply. So just as a refresher, Rule 410, just like Rule 408, says in criminal cases, you cannot use the negotiations that are trying to work toward a plea bargain in the defendant's criminal trial in case those plea negotiations break down. Why would anyone not want that? And the answer is prosecutors wouldn't want that. And here's why. Prosecutors want to make sure that, particularly when they're trying to break a large criminal conspiracy, and this is more common in federal court than state, but when prosecutors are trying to break a large criminal conspiracy, that they get a witness who they can trust, who will not leave the cooperation agreement, and that they know is reliable. And so in the Mezzananto case is an example of something that will happen to you if you practice criminal law in federal court with some degree of frequency, particularly if you represent people lower on with lower culpability within a conspiracy. So the facts of Mezzananto are that the defendant agreed to come in and give what's called a proffer. And under the terms of the proffer, the defendant will come in and will be told to basically tell everything he knows and respond to questions that FBI agents and the U.S. attorneys or assistant U.S. attorneys will pose to him. So before he begins that, though, he agrees that everything he says in the course of this proceeding can be used against him in the trial. In this case, if he testifies. If he testifies, they can bring what he says back as impeachment on cross-examination. But Rule 410 clearly says you can't do any of that. You cannot use things that are part of a criminal negotiation trying to reach a resolution of this case as evidence against the defendant at the trial. But in Mezzananto, the defendant agreed to this procedure in which he would allow that to happen. And then, of course, we wouldn't be talking about this case if the plea negotiation hadn't broken down. In this case, like all the cases where these cooperator agreements break down, it's because the defendant lied to them during the course of the proffer. He denied something that they knew to be true. So in this case, the question is whether the defendant can be required as a condition of entering into plea bargain negotiations with the federal government. Can he be required to waive 410 and agree that these discussions will be admitted against him if the plea bargain negotiation breaks down, probably because he's lied? And the Supreme Court opinion looks at the defendant's argument that he shouldn't have been forced to be put to this position, because the defendant argues, and it makes sense when you first hear the argument, procedurally this doesn't seem fair. How can it be the case that as a defense lawyer you could be called and told, tell your client to show up, we're not going to tell him what we know he's done, we're not going to tell him how much leniency we're going to give him, and have him basically confess to everything he's ever done that we may or may not have information about, and implicate everyone else. And if he lies at any point, then all these things all these confessions he's now made will be used against him. That seems really heavy-handed. That seems like the prosecution is able to force the defendant into an untenable position, and that Rule 410 is there to prevent that unfairness. That's the defendant's argument. And on its face, that makes a lot of sense. Justice Thomas kind of dismisses the argument, saying, look, there's a lot of heavy-handedness in plea bargaining, and kind of moves on. There's a more sophisticated answer to this, however. In many ways, these types of proceedings can actually work to the defendant's advantage, and here's how. In an ordinary negotiation, as we would think would occur, and typically does occur in a state court, The prosecution will say to the defendant, look, you and your buddy are both charged with first-degree murder. I will give you second degree and give you 20 years for that crime if you'll testify against your buddy. Now, that's, here the defendant knows what he's being charged with, and he knows what he's getting out of the deal. The problem, though, is the prosecution in that case will have to have the jury hear that that was the deal that was made. In the case of Mezzananto, let's say the plea didn't break down. Let's say that Mezzananto had continued to be a cooperator. Well, the process would have looked very different, because when Mezzananto took the stand to testify against his co-defendants, he would be asked, what kind of deal were you given for this testimony? And he would honestly be able to say, I wasn't given any deal. I was told that my cooperation would be considered at sentencing, and he wouldn't have been sentenced at that point. So in this way, the prosecution, in an odd way, will probably be more lenient than they would be if they were making an express deal. An express deal has to be disclosed. Now, why would the prosecution, after the case is all said and done, why would the prosecution at that point be willing to reward Mezzananto for his cooperation? It's not like they particularly like Mezzananto, or we have no reason to believe that they would. It's not about Mezzananto. It's about the next case. That if a U.S. attorney gets a reputation as bringing cooperators on and not rewarding their cooperation, the next time a defense lawyer gets a call, whether it's the same defense lawyer or another one, because defense lawyers talk to one another, then that defense lawyer will not bring his client in to be a cooperator. The more lenient that prosecutor is, the more the defense lawyer will encourage his client to come in and be a cooperator. So the fact that it's set up like this, that the defendant very much has something to lose when he comes in, that he's not just coming in offering some random things, seeing what kind of deal he can get, and knowing it won't hurt him if the deal breaks down, that's not something that the prosecution would be willing to reward, and it's not something the prosecution could trust early on. Because if the defendant knows his lies have no consequence, that they couldn't then later be used, his statements couldn't then be later used against him, he would have no reason to be completely, absolutely honest with the prosecution, and the prosecution wouldn't then know the full extent of the conspiracy and wouldn't know that it could trust this particular cooperator. So in getting a cooperator that it can trust, because there's a real threat, you lie and all this comes in against you, there's an upside for the defendant. By entering into that deal, the prosecution will want more people to enter into that deal. So the prosecution will want to deal well with the Mezzanantos of the world, so that more defense lawyers will bring more cooperators to them, so that this process of open information sharing that's reliable early on, that will help them break conspiracies, will happen with greater rather than lesser frequency. So even though it seems odd to allow the prosecution to say, if you come in, we promise you nothing, you give us everything. If this breaks down, you've now given us the statements with which we can hang you. That is what's going on in Mezzananto. The prosecution is saying, we don't know what you've done. You're going to come and tell us what you've done. And if you lie about it, you've now given us the goods to hang you. It's really scary if you are a young defense lawyer trying to explain this to your client. But what's very interesting, and this is just saying this again because it's in a different way, the prosecutor has every incentive to deal well with your client. That's not a promise, that's not a guarantee, that's not a quid pro quo. But there's a real incentive for him to deal well with your client. So Mezzananto stands for the proposition that the parties can in fact contract around this this system, that it doesn't discourage plea bargaining, and that in fact it may create additional fairness or additional opportunities for the cooperating defendant that really weren't there before. But it lays out for you the idea that the normal rule is that all these things are protected, and that the parties, though, can contract around this. The only time you could imagine it really happening would be a situation like this, and it does absolutely appear heavy-handed. It turns out, though, because of the repeat player that the prosecutor is, it turns out to work out pretty well, though, for defendants who are in fact cooperating.